We got to item number 12, supplementary list. I pay for withdrawal of the IA 1038, which is listed today. Okay.
Item number?
12.
You're there in the matter?
Yes, I'm there for the item number 5 in the criminal appeal.
Appellant number 5 in the criminal appeal.
Yes, he is the applicant in the first interlocutory application, which is listed today. He is the applicant number 5.
Okay. Mr. A. Ganguly, learned counsel for the appellant number 5 in the connected appeal, who is the applicant in this IA, seeks to withdraw the IA. Mr. Who are present? There are other counsels also.
Yes, he was here.
You're there. Okay. No, I'm just recording your presence so that there is no objection now. Mr. V. A. Chaudhary, counsel for respondent number, appellant numbers 2 to 7. And you're also there?
Yes.
And Mr. P. D. Bora, learned counsel for respondent number, appellant number. Okay. Okay. Appellant in criminal appeal 82 of 2018 are present. So, this player having not objected to my business as Bora and APP, is allowed. This interlocutory application stands closed on withdrawal.
Right.
And this appeal will go, what will be done with the appeal? What orders is required to be passed in appeal?
In the appeal, it is awaiting service report for the acquitted persons. As per the office dated 29 to 24.
Service report awaited. Just check up. Just see this. Because we don't want for service to be pending, we matter to be pending. It's a 2018 appeal. We can't permit delay.
Your Lordship, there was a law point involved. That is why we have come against conviction. But the Honorable Court said it will be remanded.
No, that is something else. Service report, unless we got no point hearing what is the matter about. Who is this respondent number 2? Bahadur Ali. He's the informant. In the appeal, you write the counsel for the appellant. This will be in appeal 85 of 18. Whatever be 85 or 18. Here you will write the learned counsel for the appellant shall take fresh steps for service of notice on respondent number 2. You are there.
Tell you there are
on respondent number 2 by usual process, which shall be routed through the Court of Chief Judicial Magistrate. Satyabari has that.
yes, number 20%.
Oh, she's already appeared. Nalagi. Your name? Your name? Miss, counsel for the appellants as well as Ms. S. Hussain, counsel for the respondent number 2 are present. Also, Ms. S. H. Baral and APP. So accordingly, case ready Zigat service. This the paperwork has been prepared. No. Paperwork prepared.
Your lordship, goes to the order dated 15/6, and Justice Michael Nelson, 15/6/23. The person, if it is in the cross case, is supposed to appear. For the elaborate order, but only because the acquitted persons were not made a party, that is why it was to be remanded. 15/6/20. In paragraph 15, in a page 9. The matter was already heard. But their rights will be also affected, that is why the court found it fit for them to be made party. Before remanding the matter.
My lord's order is also there, 18/9, my lordship's order. Again, issuing fresh notice to the persons equivalent 347. Yeah, order date 18/9, my lord. Okay, ma'am, heavy. Okay. Price would be around, and I to 81. Actually, to
So all the counsel here in this matter, and especially as public prosecutor, you will also deliberate and then tell us at 2 o'clock. You see, in a criminal appeal, let us say in this case, 4 or 5 people have come in appeal against the order of conviction. 3 people have been already acquitted. Now, even if we think that matter has to be remanded, can I set aside the order of acquittal even by giving a notice when there is no appeal? State has not preferred an appeal. So without an appeal, how do I derive the power to suo motu set aside the order of acquittal? Where do I derive the power? Under which provision? Even if I issue them a notice, number one, there's no order impeding them. At that point of time, we did not apply a mind when I was passing the order on 13th. I did not apply the mind. Now, 18:9, when in the bench when we were passing an order, we did not apply a mind then. But please tell us, what is the procedure of entertaining an appeal against acquittal? How do you do it? What is the procedure? Tell us. No, how do you do it? As per CRPC, how do we do it? I have a criminal leave petition, or we can do it by way of an appeal. Leave petition is required. So therefore,
If the state files, मतलब the leave petition is required, if the victim themselves come, then the leave would not.
that's not required, correct. But here they have not come. Against the victim has not come for setting aside their acquittal. Therefore, the petition is required. Correct. Even if we do it suo motu, I don't know whether we have the power to wish away this leave petition. Number one. Now, if we have to take it up, then somebody will have to move it. We have to either the state, we compel the state to file an appeal, or we compel this informant to file an appeal. And then, as law provides, either leave petition or something, we pass an order. And then we hear the acquitted accused persons. Or under CRPC, we have otherwise powers to call for the accused person and take their opinion. Question of them being prejudiced is not even near to us, because the law is, you see, in a trial can be split. When the accused one accused is absconding, we can split the trial. Now, if there is an order of acquittal and which has attained finality, can we not split that part of the appeal and then proceed against only those persons on whom we wanted to remand?
In fact,
If I may,
Just
one is railway.
এটাৰ evidence rely কৰি এটাত দি it is wrong. Acquittal laws, আমাৰ conviction is to counter acquittal law. আমি against conviction আহিছো, এটা কোৰ্টে দেখা পাই judgment is wrong, বেয়া কথা বল উঠি গ'ল, acquittal উঠি সেইকাৰণে acquittal কেইটা আনিব খুজিছো। Rely কৰিছে।
Or there is another alternative. We direct the registry to suo motu register the petition on behalf of the state in view of the inherent violation of the principles of passing a judgment. At 2 o'clock, please address us on the law point involved. Because in a criminal petition, I don't know whether the court has power to issue notice on a person, although we have done so. But power of a court to issue notice on a person who is not a party. No, we have seen that. But can we take cognizance of a notice issued to a person who is not a party to the appeal and then decide the matter?
Then notice would have to go to the person's equity.
No, notice is already sent, well, already served. But that's not the only issue.
Suo motu power also. That would be exercising section case 131, wherein we have been convicted because 3 persons have been acquitted in our case, my lord. And the cross case as well, my lord. Because all 4 have been acquitted in the cross case, my lord. That was lodged by us, my lord, the present appeals.
But they are not parties here.
They are not party there. And
Then-
last occasion, lord,
Then either you make them a party if it is your appeal against acquittal. Your appeal is not against acquittal. Then you can't do that. So we'll have to direct the state to file a leave petition against the acquittal, because you see, I don't know of power of the court to issue notice and to proceed in the matter when they are not parties. Can we decide the right of a party without them being implicated as a party in an appeal? You see, because we'll be laying down law also, that the court issued a notice and then set aside the acquittal and send it back. Do we have the power? Tell us whether we have the power or not. Because the state can always come up in this sort of situation to file an application and then plead condonation of delay. Because you see, insofar as the prosecution is concerned, the state has the paramount interest. You can't permit a wrong law to be laid down. Because if there's no 2 appeals, two cases were not decided analogously, it is an inherent defect in the judgment. My brother is absolutely right. This has to be interfered with. But what will be the procedure? Can we just issue a notice on someone in a criminal matter and expect him to respond? If we are doing it, then why a trial court can't just issue a notice to someone? He's not a witness, he's not a party to an inquiry. We just issue notice. But please address us at 2 o'clock. Just go through the relevant law and address us. Because the alternative is that we are direct the state to file a, or so much we can register and this leave to appeal application. But tell us the law, we are not very sure about our powers.
keeping the acquittal
Pardon me?
judgment as regards the appellant's claim. Because we were prejudiced because the witnesses in the other case were used to give witness report in our case, we used to convict us. Then only our part will be set aside, and a fresh finding can be come out of.
So in one appeal, we can't split up and give a decision, in fact. We don't know. That's something which can't be done. A judgment can't be split up. Trial can be split up. Proceedings can be split up, but we don't know.
Procedure was wrong.
Procedure was wrong. But can we adopt a wrong procedure again to rectify what was wrong? Because we'll be laying down a law. Once we decide that, it will be a precedent. Can a judgment be split? Trial, I can understand. Appeal is extension of trial, we can do it. But should we do it? In a judgment, we split up and say that on these people, notice was not served and therefore we split up. And they are not even a party. By what power we invoke our jurisdiction to split a judgment when the people who are acquitted are not even a party here? Because then we'll be following that old, what you call, old act often applied, which is called Pare Act. That is as at 2 o'clock. Please be sure. We'll have to be sure before you pass an order.
Right.
May I please, Your Lordship? First, I beg to mention item number 10 of the daily list, Lordship. Lordship, I beg to mention item number 10, Lordship. Matter may be passed over for the day.
Hearing matters will be rolled over. We are not passing an order. At the end, we will pass orders.
Right.
Item 10, just mark it. Item 10. Yes.
Item number 9 of the daily list. Legal aid counsel for appellant is out of the. Kindly pass over and make up to the daily.
Okay, with the prayer made on behalf of Legal Aid Council, the matter stands adjourned today. List after 2 weeks.
Daily list item 1 for motion.
Yes.
Not, we fair to this on report. Actually, does not come under the contemplation. But why we have preferred a contemplation? It was by the same parties. Actually, the facts of the case is this, that the divorce was granted, accorded by this court. On the compromise arrived with between the parties. My client is the husband. He failed during the COVID period. He failed in payment of some amounts. So the wife preferred a contempt petition before this court. And this honorable court was pleased to issue notice to us. We appeared. And we, taking 2 or 3 months' time, we have complied. Out of those terms and conditions, one term was there that I have to give her a flat during this stretch of Sanmari to Panvel. And in front of HDFC Bank in Senikutinwala, where chose a flat, she also agreed. And she signed registered the agreement for sale deed. Now I am going to make the final payments for the final sale deed, registration of the final sale deed. She does not have. On one pretext or the other, she has refused to accept this agreement. So I have taken bank loan. Now I'm suffering the pain of paying the interest and the other amount, principal amount of the thing. Since this honorable court has taken a note of this thing and issued the notice, under the contempt of court act earlier. So I prepared this, with a folded hand prayer that once the divorce was granted at the behest, on the basis of a compromise deed, and this court was pleased to pleased to make that compromise deed as a part of the decree.
Mr. Sama, we would be very happy, but unfortunately, that is not the law.
I understand.
Because in a divorce suit, we have an execution proceedings.
I understand. Bill.
And
That
second
why
thing is,
my opening statement was this.
no, but and the second thing is that this you can always apply before the court to what you call to waive enforcement. Once he is not accepting, those are you'll have to explore. Because law will have a better mind to what you call advise. And since you have lost that right, both of us. I can't possibly give you a suggestion, but if what you call, you'll have to record it in the trial court, what has happened.
Well, may I pray something? May not be within the framework of law, or may not be within the framework of rules. Sometimes, my lord, lordship definitely can do that. Lordship hands are not tied. If she can be called by a simple limited prayer notice, my lord, that
In contempt jurisdiction, no. Perhaps in another jurisdiction, we could do
I
it, but
filed one I also in the matrimonial appeal.
no, sorry, Mr. Sambhav, we'll have to close it. And this interlocutory application can't be exercised here in contempt jurisdiction. Perhaps in the appeal, you can,
No, interlocutory application I have filed in the matter appeal. There's a matter appeal, my lord, which was disposed of.
No. This is registered in contempt petition 111-619.
I number, I 619.
I-619 is registered in this contempt.
I filed I in matter appeal.
We don't know about that, but it is registered against this contempt petition.
I filed two petitions, my lord, one contempt case in matter appeal and one IA in matter. If lordship pleases, my lord, can issue a notice in the IA, my lord, if not. inconvenient.
When we are not entertaining the contempt petition, we are not issuing notice in the IA attached to this. You see, the cause list also, it is showing like that only. 619 is in contempt, 111.
May I look into it?
Ah, yes. Look at the cause list also.
I mentioned in the first title at the IA in matter appeal.
Maybe you can withdraw it and file it there. There's no issue with that.
Oh, my lord, this IA in contempt case, that was this. That's wrongly mentioned, my lord. There's a mistake in the,
Permit you to withdraw it and then file it there. You can permit you to withdraw it and file it there. There will not be a
in the matter appeal only.
matter of it only. In the IA, right, this A. Samuel and counsel for the applicant submits that the appeal is wrongly registered in connection with the corrected contempt petition. However, he had filed this interlocutory application in connection with matter appeal number
Matter appeal number 8/2007.
8/2017. Just, next para. According to the comma, the prayer made by learned counsel for the applicant, comma, we are inclined to directly register to re-register this, to tag this interlocutory application along with the said MAT appeal number 8/2017.
17.
In the contempt application, right? But Mr. A. Samwat and counsel for the appellant, petitioner, so by filing this contempt petition under Article 215 of the Constitution of India, read with Section 11 and 12 of the Contempt of Courts Act, read with Rule 3 and 4 of the Contempt of Court within bracket Guwahati High Court rules of 1977, comma, the petitioner, comma, who is the estranged husband of the respondent, is alleging willful violation and disobedience to the order of this court dated 13/12/2022, passed in contempt case number 92 of 2011. Where is that order? Where is that order?
That is
13/12, page 650. Okay.
the 31.
Uh, The said order is quoted below, page 50/51. Next paragraph. The learned counsel for the applicant has submitted that the applicant, comma, with the consent of the respondent, had booked a flat for which the agreements were signed with the builder, right? Mr. Samuel, with the builder, you made that agreement.
Not builder, it's a second use flat. It is a use flat. With
Oh,
your
okay.
land owner, flat owner.
Oh, okay, with the concerned flat owner. So it is also submitted that the applicant had availed bank loan to purchase the flat and however, comma, the respondent has refused to take possession of the said flat. Next paragraph. In the opinion of the court, as the orders passed, for providing accommodation of the respondent, comma, is otherwise an enforceable order. Considered opinion, the no case of willful deliberate violation of the order passed by this court in contempt proceedings is made out. Next paragraph. Nonetheless, comma, having regard to the prayer made by learned counsel for the applicant, comma, sorry, petitioner, comma, is permitted to avail any other remedy that may be available in law for demonstrating before the concerned, before the appropriate court that he has made available a suitable accommodation for the respondent in terms of order dated 13/12/2022, passed in contempt case C 92 of 2021, in such manner as he may be so advised, as the petitioner may be so advised.
But the I will be relisted.
I'll be asking it to be tagged with your matter appeal.
And then also may pray for something like that. I will be listed in the field.
No, you have to make a prayer in the appropriate manner. In session of in this contempt petition, we can't pass that order.
No, in the I am.
I is already, we have asked for re-registration. We can't fix a date here.
I'll put- I will bet.
Item 2 for admission.
Yes. Item two, item 2, 3, 4, and 2, 3, and 4. Given nothing. You take the orders from the notice and admit notice appointment of amicus curiae from the list. Notice is made returnable on. After 6 weeks, give a date. Give courier.
Yes, I'm sure. Yes.
Yes, absolutely. No. Nothing. And from this list, item serial number 30, 31, and 32. Item 2, 3, and 4, one each. Appoint them. Take- Yes, we are appointing this serial number 30, 31, 32, one Rupam Jyoti Das, Abhijit Bhattacharya, and Anup Rinal Datta. As a case. Take the notice, return of consequence. And just check up if there is POXO, then notice should be routed to the officer in charge of the jurisdictional police station. Otherwise, it will be notice on respondent two if it is there. Will be through to the concerned court having jurisdiction. Okay. You can record the presence of Mr. SS Bora, APP, for the state. Yes, item 5. We issue notice. Call for record. Same order in item 5. Mr. N. Burman for the appellant. Mr. R.K. Chaudhary, learned DSGI for the respondents. Respondent 2, and Ms. S.S. Bora, then APP for respondent number 1. Huh? 1 and 3. Okay. 1 and 3. This is called an appeal or an application. It's an appeal or an application. Mhm. Appeal. Because yesterday we passed on order in the cost title, it was yesterday or day before yesterday. We wrote as application because in the cost title it was application. And somehow I registered it in my mind and therefore I asked you today. It's an appeal. This is an appeal under section 21 of the NIA Act, 2008. Asserting the order dated page 2, 24/1/2024, first cost item. Appeal is admitted for hearing. Call for the records. The scan copy of the scan copy of the records. No steps is required to be taken as all the respondents are represented. Next, the requisition for records, scan copy of the records shall be sent by the registry through email to the concerned special judge near Assam and Guwahati, with liberty to the said learned court to send the scan copy of relevant records to the court through the by email for being placed before the court. So objection, if any, by the respondents be filed at least 2 days prior to the next date of listing. List on when?
After 4 weeks. After 4 weeks.
So we give a date. The 4 weeks.
5th of March. 5th of April. That's right.
Yes, item 6. Why it has come?
Six worship, they were counted on the other side and appeared initially. They were required to file an objection. They are not appearing and not the following.
Sare Mazumdar. Yes, they are absent. Okay, Mr. R.K.D. Chaudhary, DSGI is present. On 6/2/2024, on the prayer made by learned counsel for the respondents, the court granted time to file objection. Full stop. So the matter was listed thereafter on 19/2/2024, but there was no representation from the respondents. For which the matter was adjourned and was relisted today. Today also, the none appears on call for the respondents. So, they are already released.
Yes.
They've been released.
Shifted the points of one from the panel. There was. It might cause some.
For cancellation.
For cancellation, we can't do that. So therefore, first of in view of the persistent default on part of the respondents to enter appearance, Kamali Court proposes to hear the matter on the basis of materials available on record. Full stop. However, we request the learned DSGI to give a SMS or telegram message to the learned counsel for the respondents on record, and a printout thereof be placed before the court on the next date. You collect the numbers, I think it will be here. So this is the matter for hearing on. Give a date after 2 weeks.
On 22nd?
22nd.
March.
You just give them a message and then.
Item 7. Items.
Item 7, yes. Yes.
As per office note, dated 27th of February, Your Honor, no objection filed on behalf of the state has been received.
Okay.
But appellant received the objection of the IA for granting bail, but that number is wrongly typed as 1106. It has to be 1135 of 2023.
Lordship, one of my senior has filed this lordship objection. It is their lordship. But I have not filed today, only found this on the lordship. I don't know whether it is filed or not.
Okay. She is saying something. You have heard her? No.
111106.
One,
Yeah, it is.
it is wrongly typed as
Okay.
1106, but it has to be 1135.
11:35.
That was the number of the IA for condemnation for delay. That is already disposed of.
But moreover, yeah, it is written that LCR is received lordship, but I have not found the LCR lordship.
No. This objection will be in 1135 only. In your copy, what is the date? What is the number?
It's the number 1106.
1106. Oh, then it will not be here. Just check up.
The name is the same lordship.
No. Name may be same. There may be 100 Mr. Sharma. But when you dial a mobile number of Mr. Sharma, number 1, the connection will go to number 1 only. It will not go to number 20. Correct. The same thing here. We do the rectification. Do it within 2 days. We'll take it up on Wednesday. Ms. Anna and counsel for the applicant has submitted that she is in receipt of an objection by the state, which is wrongly mentioned in the cause title as objection to IA criminal 1106 of 2023. So it is submitted that the said application is already disposed of, and therefore the objection by the state is not tagged with IA criminal 1135 of 2023. Most probably Mr. K.K. Das, learned, the APP shall do the necessary corrections and if he is unable to track the objection, the state is granted liberty to file a fresh objection. List on Wednesday, you will be able to do it. 6/3/2024.
Item 8.
Yes. Yes. For, oh, continuation or delay. Okay. How much days? 9. You have an objection? No. Oh, acha, respondent is there. Respondent number 2. Okay, Hermes T. Som, learned counsel for the applicant. You should notice on this application filed under section 5 of the Limitation Act for continuing the delay of 9 days beyond the period of limitation in filing the connected appeal. The notice is made returnable on 6 weeks after date. So,
19/4, 19th of April.
as Ms. S.H. Boral and APP accepts notice on behalf of the state, no steps is required to be taken in respect of the respondent number 1. However, the learned counsel for the applicant shall take steps within 2 days for service of notice on respondent number 2 by registered post with AD, as well as by usual process to be routed through the jurisdictional Chief Judicial Magistrate, Goalpara.
Aniket Velu, no?
The concerned court in charge of process shall ensure that the service report is returned prior to the next date of listing. List on when?
19th of April.
19/4/2024. What is the offense? Oxon. Okay.
Supply item 14.
Mr. Sharma, we'll adjourn this matter because today we intend to complete that criminal appeal part. We'll take it up next week because this will take some time because we have to, we wanted to go through the merit.
Yes.
Correct.
I have
But today we have to close this.
take time because
We'll have to close this matter first. If you want, we can take it up at the end of the day if you want, or otherwise it will be adjourned.
today, yes, Lordship, I'm ready. No, forget that. If even I will here, Lordship. Second half, I will come also.
Item.
Yes.
I think we'll adjourn it because this may take some time. We intend to close this. We don't want to, what you call, detain you.
Then I have only
Hmm.
lot of some matters, otherwise thereafter I am here. Lordship, if you can take up, then no issue, that matter comes and otherwise.
No,
issue,
because-
forget, but I will be here.
No, because we also have single bench. The difficulty is only that.
Then Lordship.
uh,
they will be-
Tuesday or Wednesday?
Tuesday. Tuesday.
Tuesday or Wednesday, any day you choose. The calendar is there,
7 Lordship.
7th.
7.
Okay. As the Mr. B. Sharma, counsel for the applicant, and Ms. N. Das, APP are present. So as the court is hearing a parted matter, the court is compelled to adjourn the matter today. List on 7/3/2024.
Supplementary item 15 to 27, part heard.
Oh.
इसको अपॉइंट करने का
May I please, my lord?
yes.
My lord,
Mr. Singh, you are now in Guwahati or you are practicing from Imphal?
mostly now I'm in Imphal.
Okay.
Because of the situation in Manipur, I cannot leave my mother out there. My father is there. Because of that.
Okay.
But I'm also handling cases here. I should.
Oh, you keep coming. Okay.
My lord, the argument. Yesterday, my uncle Strada was there. My father's brother Strada was there in Nagaon. So I had to go there yesterday.
Pardon me?
Yesterday, my uncle's father expired, so I had to
Oh.
go to Nagaon.
Oh, I'm so sorry.
My lord, what my learned friend, Mr. Chaudhary, and my learned senior, Mr. Tanas, we are simply, my lord, I just want little clarification. So far, 65 years comes. My lord, that particular point was raised before the trial court. So, my lord, I respectfully take, my lord, part 1, volume 2, PW number 53, my lord. Just a simple clarification.
Part 2 volume?
Part 1, volume 2. PW number 53, 302. Page number 302, PW number 53. Is 302, the relevant portion, my lord, would be 322 on cross. 322, 322. My lord, Satishan, PW 53 on cross, my lord, the first line itself. My lord, if your lordship is found, I am well aware of the provision laid down under 65B of the Indian Evidence Act. I complied with all the legal requirements as provided under the said provision while issuing a certificate under so and so. I did not mention the period over which the computer was used regularly in my certificate. The same was not required as per the provision of section. I did not mention the specific words that the very so and so, so and so. My lord, the pertinent question was put that particular 114 that has been issued without compliance of the 65B, my lord. So he said that he knows every provision and it is, and he has accordingly, that was issued. My lord, that was on prose, my lord. And PW number 74, my lord, that my lord will find Siva Prasad Mohanty, 385, page number 385. My lord, 386 is a cross, my lord. My lord, same thing is
Mr. Singh,
Lord.
you see, when we are reading this objection at the cross-examination at page 322, you see, you have asked him, are you aware of the provision of law? He says, yes, I am aware.
Yeah.
Then you ask him that whether you have complied with the legal requirements. He said that, yes, I have. I have complied with the legal requirements. While issuing certificate at exhibit 114.
I never mentioned.
I did not mention the period over which the computer was constantly used. Therefore, now you are specific. First objection is whether the computer was in use, which is first part of 64. Then he says, I also did not mention the specific words that to the best of my knowledge and belief in the said certificate. So therefore, these are the two objections raised. The objection that he does not have a certificate of the printout was not asked to him.
Yes, that particular, but again, if we come down, it is not a fact that a certificate one issued by without complying the provision of 65 when evidence A. Again, it has come. But if it also goes down to 6 9,
No, but vague questions in cross-examination, how far it will lead to a presumption that he was made aware of the printing statement was not there.
of course, my lord, I should consider because here, but the question is that particular 65B certificate was not issued in compliance of 65B4. That will include everything, my lord. How the printout was taken, how everything was taken, because 65B4 certificate has to mention everything, my lord. So our question that he has not complied with the 65B4 certificate. That is a whole, my lord, thing which I can summarize and submit before it also. It's the same question was asked to PW 74. He has replied in the same manner. Because the argument advanced by my learned senior counsel as well as my learned friend, Mr. Chaudhary, was that on 65B, no discussion was there in clause, my lord. That is
Okay.
what. There was certain discussion that it was not complied with.
Okay.
Even in 74, my lord, in the same line, the clause was. This is one clarification, my lord. Okay. And so far, my lord, there was a lot of discussion.
Where is that PW 74?
W 74, page 380.
Same thing.
Same thing, same question, my lord. My lord will find the relevant portion 386 and PW 74 starts from 385. The same question, the same nature of question and the same answer has come out from PW 74 also, my lord. The issue regarding 65B4 was raised even in the course, and even it was raised at the time of the hearing. And my lord, there was another pertinent question, my lord, that your lordship put like yesterday, my lord. That's, I have come to know from my learned friend, Mr. Raz, regarding the edges, the time bound matter under section 28 unlawful activity, my lord. Edges, my lord. Whether I have filed appeal within 30 days, that question came up, my lord. My lord, well, at the time when Nia came, my lord, this was the second case in Guwahati. The first was DSD. So everybody was new. NIA was new. This amendment was new. Everything was new, my lord. Well, that I cannot say the ignorance of law cannot be a ground. My lord, in edges, my lord, that order was 26/7, my lord. And the certificate that the filing was on 26/8/2013, my lord. So we often, the order on 3rd of August that I have made there's a specific statement with regard to that my lord will find in part 1, volume 5, page 110, my lord. Part 1, volume 5, page 11110.
Dasi. You get file criminal appeal 257. Yes, volume 1, part 1, volume 5, page.
110. There's 110. That suffices the order of the proprietary is yet to be.
Just a moment. Yes.
No, the 110 said the order of forfeit is yet to be formally received by the appellant. However, through his lawyer, the secretary could obtain a certified copy of said order only on 3rd August 2013. So certified copy was obtained on 3rd August 2013. Therefore, my legal submission would be like it was within 30 days time. And another legal argument.
Just a moment. But there is another ground taken by Mr. Das that under the law, you have to file it before the government. You read this section, what it?
I'm coming.
Huh.
Yes, of course, I have considered myself that was a very new thing, that second case of Nia. So everybody was new. My another legal argument is that particular appeal was filed under 21 of NIA. Your Lordship is quite aware of the fact that under 21, that has to be filed within 30 days, and it can be extended till 90 days. That after 90 days, no appeal could be filed, but this is an appeal because it was little confused with the Milord. If I respectfully tell Milord, to NIA section 21 of National Investigation Agency of 2008, Milord. With your Lordship's permission, I'll just read on, Milord. Section 21 of NIA says, notwithstanding anything contained in the court and appeals alike from any judgment, sentence, or order not being an interlocutory order of a special court to the High Court on facts and on law. Section 21. Appeals. The provision, any order passed by NIA, there is a provision for appeal. And that has to go before a division bench. So
Which provision?
21. Appeals 21, NIA 21.
NIA Act, okay. Yeah, Act, NIA, National Investigation Agency Act.
Now,
Any order. Sentence or not being an interrogatory order. Yes.
this is if 21.
Just let him complete his part. We'll come to you.
That any order passed by the NIA court, madam, we have to prefer an appeal before it, that will be decided. Will be placed before the division bench. Now, so far this is concerned, my lord, if I tell you about safety proviso, provided that provided the High Court may entertain an appeal after the expiry of the said period of 30 days, if it is satisfied that the appellant has sufficient force, will not prefer the appeal within the period of 30 days. Provided further that no appeal shall lie entertained after the expiry period of 90 days. My lord, my humble submission is, maybe I have, my lord, as per unlawful activities A, if that is order passed under 26, I have to prefer under 28. That's one aspect of the matter. But having passed by the learned special judge NIA, my lord, I have preferred this appeal under 21. So under 21, it has to be within 30 days and it can be extended. And my appeal was accepted by the registry because they might have checked and it falls under 30. I'll not comment on the matter. But even then, that has to be expanded. It can still be, it still can come under 90 days. So the conflict is the order passed by under unlawful under 26 by any court. Another conflict is order passed by the NIA. Now this 21 is a non-obstative clause, my lord. Any order passed by NIA court has to go by way appeal under section 21. My lord, my interpretation of law may be different, my understanding may be different, my lord. So I have preferred this under 21 of NIA, not under 28 of unlawful activities, my lord. Yes, it's right. I have not preferred under 28, but others is under 21. That is only clarification that I can now submit before your lords because the record will reveal everything, my lord. The another aspect of the matter, my lord. Yes, so far Aegis is concerned, my learned senior D.K. Misra has argued on behalf of Brazevido. I argued on behalf of Ibomcha. And unfortunately, Bomi expired during this particular pendency of the appeal. Now, in the event, because they are the one who has been running Aegis and they said that it's run by them only. Now, in the event, if both Mr. Brazevido and Mr. Ibomcha gets acquitted in this matter, because there's no linkage. Because this is not a process of terrorist act that Lordship has come clear because there's no evidence on that. Now, in the event, my preference of appeal may be wrong only on the wrong provision of law. Let's put for a timing, let's tell about. Now, what will you fed of Aegis if both are acquitted? Because the property belongs to them. There's nothing to show that these are the process of terrorism or nothing to show that these are the process of terrorism. Now, what will be fed of this particular property? Look, that aspect also has to be looked into, my lord. Maybe I have preferred under a wrong provision for the timing, let's assume for the timing, my lord. But having passed by the NIA court, my lord, the NIA Act, any court established or constituted under this particular statute, my lord, that any order passed by NIA court has to be preferred under 21. That is what the Act says. But again, UAP says that has to go under 28, my lord. That is the confusion, my lord. So I have chosen under 21 to prefer this appeal. That's my humble submission. And so far other things are concerned like email, because E is not exhibit. Emails, I'll not go to that extent.
In this point, let me hear Mr. Das on this maintainability of appeal.
It is not a submission, madam. Only a correction, madam. Sorry, madam. Section 21, which we are referring on, that is an appeal shall I guess judgment, sentence or order. He is taking that this order. There is specific provision in UAP Act. Yorosme kindly, actually Yorosme has gone through the 25 6. 25 was 6. Number 1 and 25 and 28. 6. Any person aggrieved by an order made by the designated person may prefer an appeal to the court in the period of 30 days from the date of receipt of the order. And the court may either confirm the order of enforcement of property or seizure or made or revoke such order and release the property. That is one part which
No,
Next.
I think we'll accept the argument of Mr. Singh. You see, for two reasons. Number one, please come to this, the provision which you are reading, section 25 of unlawful activities. This provision says that what are the powers of the designated authority? And in this 25, you will not find a single uh, provision referring to the orders of the court. And therefore, when order is passed under 26, which is the court orders the forfeiture of proceedings, then 28. So appeal not under 25, but under 26, appeal will lie to High Court under 28.
exactly.
Correct. Now, this is within 30 days. He has demonstrated that it is within 30 days.
No,
Correct. Number one. Number two, the second reason is that NIA Act is a subsequent legislation. And therefore, we'll have to presume that the Parliament was aware of the earlier existing legislation when, therefore, the Parliament was aware of Unlawful Activities Prevention Act. And therefore, in the new act, when they provide a forum for appeal, then Mr. Singh can't be ousted.
Not controverting anything what your lordship is the complaint. The only thing is that, my lord, what about after the designated authority taking whole thing into account, there is a provision for appealing to the making an appeal to one part, making a reparation to the designated authority. The second part, if it goes against him in 25(6), he has to make an appeal before the trial court.
You see, you just have to show that,
Yeah.
when the order was passed, it was served on him.
No. Your lordship has to see the impugn order. The impugn order that was.
Yes.
That- What else? What is my name? Nine.
Yes, which part you wanted us to see? Which part of the order you wanted us to see?
Impugn order. that
No,
was-
order is before us. Which part?
The only thing is that. No.
Okay, we'll give you the our copy.
Either to Mr. Chaudhary or to me, I think he has also not got the order.
It will be.
It is not a press submission on this.
Order like that.
Tomorrow nine, huh? আচ্ছা, ঠিক আছে। হ্যাঁ? এইটো নয়? চাই লওঁ।
Because Mr. Das, I'll just interrupt you for a moment. You see, we have a concept. We don't know if it is acceptable or not, but we have a concept. In a criminal judgment where sentence is awarded, accused has a right to a free copy. So therefore, when a copy is served by the court, then the time starts to run. For the limitation, it starts to run. Here, in regard to the order of forfeiture, which was passed by the court, the order of the copy was not served on them, on the appellant. Apparently, it is not. There is no order of serving. So whether service is made or not, we don't know. But now, in this case, he has filed a certified copy of that order and says that he applied on 3rd, he received on 3rd. So that is matching. He is right. And the appeal is filed 26th. So it is within the period of limitation. That's one part. And two, what you call, two nature of understanding that we have with regard to this subsequent enactment vis-a-vis the prior enactment. So they are to show that the legislature did not intend, because if there's a date of notification of that provision, 21, if it has been notified, appointed date, then you can perhaps argue that the legislature did not intend section 21 to override. Because if there is a legal provision available, then whether rightly or wrongly, he has chosen a forum to go. We cannot legally prevent him from agitating his right because it's a statutory right. So estoppel against the statute, this will be the third argument we'll want from you. Can there be an estoppel against the statute? The statute says you file an appeal and we prevent him. So there's an estoppel operating against statute.
What your lordship is in one part of, no, can I read the impugn order?
Yes, yes,
Page
please.
3, mother. Page 3. That is, the petition further discloses that the information of a aforesaid attachment order of the property of Aegis was given to the designated authority by SP NIF on 12/11/11. The designated authority MSA by this order dated so and so dated 24/11 passed the order of process under provision 25(3) of the UAP Act as amended in 2008 and gave 2 weeks time to the parties aggrieved or likely to be affected by said process of attachment. It also stated that accused and Bhumi Singh, he is accused here in this. By his acknowledgement receipt dated 22/12/11 in respect to the above mentioned order of MSA had mentioned that he has no comment report on the attachment of the properties of Aegis by NI. According to the petitioner, while filing supplementary charges so and so dated have disclosed sufficient evidence to show that the investigating officer in his petition has further maintain that during course of investigation, an amount, case amount of rupees 17 lakhs, that is we have only, whether, they were, given time and what they have to say. Once Bhumi Singh has said, no, we have no objection to that. Yeah, on and
So no objection doesn't say.
that-
He merely says he has no comment.
Yeah, but no, exactly, madam, what your lordship will take it, that is a different thing. He has said no comment. Possibly your lordship has gone through this.
No, when you are reading it,
No,
because you
he
said
said-
that, because you uttered that and we remembered it only.
Madam. Then it also stated that it has been established that seized property of rupees 17 lakhs forms part of the resource of terrorist organization and is a proceed of terrorism by UNL. And a designated authority by order dated 18/8/11 on being satisfied that the aforementioned of 17 lakhs is a part of the resources of terrorist organization UNLF order for the retention of seized amount in view of the provision of section 25(5) of the UFA Act and gave 2 weeks time to the parties aggrieved or likely to be affected by the said process of attachment. According to the petition, no representation has been received by NIA, the designated authority, and any court so far from the party aggrieved or likely to be affected by the said process of attachment of the properties of ages and the seized amount of rupees so and so. Like it also contains that IO that as per the provision of laid down in so and so, the said attached property of ages and seized cash of rupees 7 lakh are liable for forfeiture by the competent court, subject to the expiry of mandatory period of 3 months as prescribed under section 25(5). The IO has further stated that that more than the mandatory period of 3 months has already expired, already been passed since the attachment of the property to ages and cash of rupees 70 lakhs by the NIA and subsequent confirmation by the designated. The IO has therefore prayed for forfeiture of the ages, property of ages and seized cash of rupees 70 lakhs under the provision of section 26 of the UFA as amended in
But just a moment, this 17 lakh was seized
70 lakhs as
from,
well- yes, from that Orun, I think, Orun or
PW 39,
the
NG Robert.
Robert or
no, but why AGs is charged of for that? How in this, how that money is shown to be AG's money and then,
no, they're not Aziz money. 17 lakhs as well as Aziz property. Separate.
okay,
Not,
okay,
not, yours will.
okay.
Whatever. It's not 17 lakhs is Aziz property. Not
Oh, no, okay, only the AG's property is separate, okay.
hard
So-
letter, so and so petition, so and so, the original FIR was registered so and so, then the order was passed. The perusal of supplementary charges goes to show that during investigation, it has been disclosed that in order to build its financial assets out of the extorted money of UNLF as a part of strategy invested the said extorted money in different project companies, including AGs, which is a food processing unit, a front company of UNLF, established, finance and administered by UNLF. It also has been disclosed that accused so and so and Bhumi Singh is secretary of AGs. Produce copies of order dated so and so passed by DGP Manipur, order dated so and so passed by SP NIA.
So if you have understood this order correctly, if you are understanding it correctly, then the government fund of 2 crore rupees was acquired by extortion and given to AGs. Government extorted money, gave it to AGs, and therefore AGs money is an extortion money.
It has not come that way. It has not come.
No, but what happened to the government money? Government gave money to do what? To create assets.
Okay, that part has not come. What is there in the record?
No, but we are trying to understand terrorism.
What
Any
is-
money collected is act of terrorism.
Malad,
So therefore, either the government did a terrorism and gave money to them, or they terrorized the government to extort 2 crore rupees.
just take in one sentence, Malad. What is happened, Malad? Please, we say that AG is a frontal uh, is a frontal, what you call farm, where this UNICEF invested their money. And
But what happened to the government money?
now, just let me complete it. And their accounts, etc., and all this thing that has been processed by UNICEF, that has been retrieved from the mail. That is only part. Nothing more else. That is why they say that, we said that, no, your distinction, you are a member of UNICEF. That's all, nothing more than. And by this order, Madam, AG as well as 17 lakhs has been seized, nothing more than. And by this order, you also will find that enough representation has been given as part of provision of UAP Act to represent. Thereafter, also another notice has been given to them that this order. However, they say that no, that what the court will do, this is the order, Madam. They also will deal with the matter accordingly. Because this order has to be sustained, my lord. Keep going. Then last part, after hearing story.
Bhaji.
I'll just complete. After hearing counsel for NIA and also after going through the materials submitted along with the petition, I find sufficient ground for forfeiture of attached property of AGs and seize cash amount of rupees 70 lakhs, which constitute the purchase of terrorism. Accordingly, the prayer for IOA is allowed, and it is ordered that the forfeiture of attached property of the LS firm, namely Association for Extensive Growers Innovative Service, and seize amount of rupees being pursuit of tourism. Hello. This, this I've just pointed out, so that your lordship, everything is come to your lordship. That is all. Nothing nothing new on this.
Well, my humble submission is like, when the order was passed on 26/7, when the order was passed on 26/7, on an application filed by the IO of the case, the court has passed this order. And by the time that we often the certificate to be heard, and I have preferred this appeal under 21, read with 28 of UAP. So that's within time. And just to add to your lordship's this thing. And moreover, now all these accounts, there's no certain allegation. They only say from the accounts and from the email that this is so far to be held as a process of terrorism. There has to be a terrorist act that is not found. The process has to be for terrorist act. That is also not found as per 21. So having no evidence under 21 and 20, my lord, in the event, Mr. Brazavidu and Mr. Ibomsa is acquitted for want of evidence, because then the fate of the edges has to be restored by the my lord. That is my humble submission. And rest of the things that my lord have been taken care of by my learned senior DK Mr. on exhibit parts. The only clarification that what has been written by PW 84, email, EE is not exhibit, my lord. These are all emails. Some are not even exhibited, my lord. It's only a mention, my lord. I also cross-checked some of the EE, which is E84 to E85, E86, 87, some are not even exhibited. He only mentioned the 84 one. E.
No, no, show us that.
Just be-
115, my lord, all the emails are.
No, but once he's making a submission, let us,
Correct, my lord.
let's see that.
1 to 19, correct. That's all. 1 to 59, E 1 to 59, what were executed by 100, by, PW, I think 50, who has executed 115.
Okay.
Fifty-three, but.
E1 to E59.
One to 56, E 1 to 56, by PW 53. The test sample.
They're all together, my lord.
Just. That's it. This is the observations by a constitution bench. It's a 5-judge bench. I'm saying anything.
That is a law.
And
Yes.
হেৰি এটা ডিচেন এটা
Yes.
my lord, even in the paragraph 41 of the, I'm summing up, even in the paragraph 41 of the judgment, it has been clearly said that this emails E1 to 101. So this E1 to 101 consider 1008 pages, my lord. Out of that, they have just chosen 88, sent for translation to somebody that my lord will find IGV 185, who is in fact translated this also, nothing is mentioned. And the one who is translated was also not called. And they will.
That you already argued.
I'm just summing up. So here the case is they're heavily relying on exhibit 115 to link up everything. So when 115 doesn't qualify 65B4, I think can be the matter. So it's a case of no evidence, in fact. So my humble submission is where the edge is below. There's no link between this UNL group and even the edges. So all these appellants to be acquitted, my lord. And most of them also, my lord. There's another, most of them have spent about 7.5 years behind the bar also, except Landoni, like he spent about.
You made a chart, you said that you will
Yeah.
do it.
They cannot give the exact date. It's 7.5 years. Somewhere it is after 2 days, after 3, but they all were released in the month of January 2007.
Just, that's.
Yes, 2007.
just a correction. Malad will just see that they were sentenced for 7 years.
Is somewhere for 10 years,
And 10
8 years and 7
Maximum
years.
10 years.
8 is for 20.
Yeah.
For 18, it is 7 years.
7
And for 121, it is 10 years.
If they have served for 7.5 years, that means they have served as an entire sentence.
That's what he's saying. He's saying that they have served out their sentence.
That's my question. And I'm, Lord, I'm handing over to Court Master.
Except Ramdhani, Rakesh and Moniton, they were in bail during trial also.
Yes, that we have recorded earlier.
That we had also produced 115 series one form from this act.
Which particular document?
Top one on your right. Right, top one. One five series are the emails printed out at NI office at the. What has been exhibited is the printouts, which were taken out at NI office, not at translated copies. You will see the, Joshi will see the emails and then the translated copy on the next page. Any of the 115 series. These emails were in Manipuri language. The translation were not exhibited.
What are you trying to convey?
That a translated copy was never exhibited. So the learned trial court could not have gone into the paper that was before the learned trial court was the one which was in Manipuri language.
Even I cannot. Because this does not have Manipuri. I tried my best, I couldn't.
So the person has stated that you have translated it, but they never executed. But the Kanpur could not have appreciated this.
Just because I'm not making a fresh submission. On the submission regarding translation, etc. You also just make a note side, paragraph 43 and 44 of the journal.
43 and 44.
43.
Just a minute.
That's all. The impugned judgment.
Thirty-three and 34. 43, 40.
Page 962.
I can do that. Volume 5, volume 5. can have the one. YouTube ভাল।
Wait and do. We are appearing for 5 of the appellants, my lord, here. For all of them, we have filed this written submission, but 2 of them have not been tagged with the file. They are in the appeal section. I'm filing the requisition, they may be called. You give a. So far as the index are there, you will.
Photocopy and give it to the court master. Because when did you file it?
30th of January and 6th of February. Long back.
We don't know.
Because the files
So
were
back.
already here. Never been.
Okay, give the requisition, but make photocopies and give that also. Yes, your 2-page chart we have received. Thank you, Mr. Oh, he is not there. Mr. R.K. Chaudhary. Okay, and you are giving it?
Motif কোনটো? That's good. Okay. Yeah.
You wanted to say something?
No.
Oh, okay. The submission in reply by Mr. B. Prasad, counsel, is for 5 appeal. To give the numbers of the trial. And Mr. M. G. Singh, counsel for the remaining appeals. First of Mr. R.K.D. Chaudhary, Tadal, DSGI, for respondent number 1, and Mr. B.K. Das, senior counsel, assisted by Ms. P.K. Darji, counsel for the counsel for respondent 2 are present. Mr. Arguments are concluded, judgment reserved. So just say, just for the Mr. B. Prasad, counsel for the appellants, has submitted that he has filed 5 written submissions in connection with appeals in which he is appearing. So let the same be made part of record. Full stop. The learned counsel for all sides have also prepared a chart relating to the accused persons, comma, exhibits and references in the judgment. Full stop. 4 sets of such comparison is also made a part of the record. Then hearing concluded, judgment reserved.
Being item 12 with 13.
Number 13.
Yes.
For orders.
Yes, emptying. The notice on that. This Mr. A. Hawk, is he available? No.
He was appearing for Mellor, the
5 acquitted accused.
8% our, yes.
So he is not present today. And this notice is issued to whom?
In our case, it's of the statement,
No. This notice was issued to these 5 people only.
but people and the cross case. 346.
P47.
Cross case.
One 54.
164.
164.
124. Abdul Bakar, Muktabar, Tajman, and Bilal. Take 164.
Same copy.
They are the family members of the informant who is here.
Yes. 164. The notice was issued to this Abu Bakr Siddiq, Mubarak Ali, Tajuddin and Bilat Ali. Is it right? So these are 4 people, but the order of the court says 5 people.
Five way between this no, 131. Above section.
Yes.
Above these 5 people, below 4 people.
Who were those 5 people who were acquitted?
They should go 3.
41.
That's it. That's এটা লোক আছে হ্যাঁ এই দুই তিনটে পেজ এটা হয়তো লোক সাইডে ঠিক করে দিন চেক করে দেবো ইয়া করা হ্যাঁ সাইডে ঠিক করে দেবো ফার্স্ট পেপার বুক নাই পেপার বুক 1 নাই Nice, all right. Yes, 162, I'm there.
3, 3, 8, 9, 11, and
Just
13.
a moment.
Page 164.
3,
3,
yes,
8, 9, 11, and 13. Lord. They are acquitted. Page 0203 is their case.
okay. Now, this order says
They have appeared, Lord.
yes,
They have.
the appearance is in 131, sessions here 131. And now we are awaiting service of notice on these 4 people, which are in sessions case 347, correct?
1, 3, 4.
In fact, 3 of them, I think. 3 of them received notice. So Mr. Chaudhary, this appeal, this criminal appeal 85 is in respect of 131.
82 also 131. Lord.
82 is also 131.
We are in. And my brother is appearing for 80. 85. Lord.
This is also 131. So in this 347, there is no appeal.
May I please, your Lordship? Lordship, my brother has gone through one judgment, Lordship, in Madras High Court that will need a little bit of homework, Lordship, that so motor matter was taken, Lordship, Madras High Court. But we have not gone through the record in detail, Lordship.
We are just trying to understand the legal query which the court had, we have explained in the morning. We're just trying to understand how to proceed in the matter.
Nothing. সেইটো আমাৰ
Okay. What we are proposing is we are considering your prayer and adjourning the matter for the time being. But we'll formulate a question that in view of violation of the procedure prescribed for deciding criminal cases where there is a cross objection, why we should not either suo moto registered appeal, or why leave should not be granted to the complainants to file an appeal. And therefore, we hear the matter on next date. When do you want? Yes, you see, we are not on the on their relationship with each other, because technically speaking, I can fight with my own wife. Correct. There is a member of the same family, so we can still fight. Son and father can fight. So that's not the issue. The issue is the issue is that in a criminal case, when there is no appeal before us, can we issue notice? And whether that would be an appropriate steps to take to issue a notice on a third party, because once he is acquitted, he is a third party. Now, there's no appeal against acquittal. You could have done it, but it was not done. No, it's not that. You see, what happens if one brother kills another brother? There can't be a compounding of case. Therefore, you can't say that since he's a family member, I don't want to proceed. So in cases where public, what you call, the public administration is affected, there we will not permit compounding of the cases. Tacit compounding we can't permit. But we are on a question that when acquitted accused persons are not parties before us, can we issue a notice, however good our intentions may be? Just one. Yes. You see, this court, when it was passing an order of 15/6/2023, took cognizance of that. And thereafter, by referring to two Supreme Court judgments, it has said that the procedure prescribed is that when there are cross cases, two sets of evidence has to be taken, and evidence in one case cannot be accepted for the second proceeding. And therefore, you see, if there are cross cases, let us say number 1 and number 2, evidence is taken in number 1 and decision is given in number 2, well, that is permissible. If the answer is no, then this order of 15/6 is absolutely correct. Now the question is that this court, while issuing notice, a circumstance is created thereafter that in a criminal appeal, to whom can the High Court give a notice? We have said in the morning, it is only a repetition of what we said in the morning. You see, appeal against acquittal is not before us. So these 4 persons are scot-free in the second case. They are scot-free. Now, when there is no appeal against acquittal, can the High Court issue suo motu notice on them? That is the problem we are now confronted with. So to remove the difficulty, the only way is that we issue we register a suo motu, either a suo motu proceeding or the appearance in both the appeals if they want to prefer. You may not be preferring, but the other may prefer. So we are keeping the options open. We are not passing a final order which may affect rights of persons, but when we are saying that we are formulating a question, and therefore, in the next week or thereafter, whenever you are able to, you assist the court in finding out that answer. Because I can't issue a notice on a third party. Just because in a criminal appeal I want. I can't issue a notice on a third party. Now, after acquittal, they are third parties. So therefore, if we implement them as parties, then definitely we have a power. And our power is not circumscribed. It's not that there are absence of power. Under 482, we have the power to rectify the defects, because you see, when there are two judgments of Supreme Court, 141 says that it's a law for the time being and we have to obey that. So trial court cannot say that, well, Supreme Court orders are there, well, be that as it may, but I am passing this order. It could not have done it. So order passed is inherently wrong without jurisdiction. And therefore, once it's an issue of jurisdiction, the High Court under 482 can definitely foray. It's not that we don't have the power, but the question is which will be the most effective way to do it. They have also not filed an appeal. Till now, they are not aggrieved. Saved by the wisdom shown by Mrs. Jahan, APP who had pointed out this judgment before the court, and therefore the court took cognizance of that position. But once we have recorded that, we have to respect this order and bring this order to a lawful conclusion. So we know the starting point of the travel, we know the destination where we want to travel, but it is only we are trying to find out a way. For some reason that road is obscure. We are unable to locate that road. We want your assistance only on that. Because this order is not on a challenge. 15.6 has attained finality. So therefore, the observation of the court, the view of the court, we are not disturbing it. We are also not disturbing the notices already issued, notice served on 3 of them. I think 3 of them have been served. Notice to Anisur Rahman is served. Notice to Sahajan Bhuiya is served. Nurul Bhuiya, it is served. And Anisur Rahman Bhuiya. So all 4 has been served. Okay, this is in criminal appeal 82. So you are already appearing for them, only for the convicted ones. Okay.
Office appearing. Those 5%.
For those 5 persons. Okay. But Mr. Record your name? Is it P.K. Das, counsel, P.K. Das, and Mr. V.H. Chaudhary, counsel for the appellants. Also had Ms. S.H. Boral under APP, and Ms. M. Hussain, F. Hussain, counsel for the informant in criminal appeal number 85 of 2018. Next. 82 and 85. Okay, 82 and 80, in both the appeals. So, in order to bring the order dated 15/6/2023 to its logical conclusion, the court is proposing to, the court is inclined to issue notice on the appearing parties to address the court as to why the acquitted accused in connection with Sessions case number 347 of 2015, namely Abu Bakr Siddiq, ABU BAKKAR Siddiq, SIDIQUE, comma, Mubarak Ali, MOBARAK, Mubarak Ali. Next is number 3, Taijuddin, TAIJUDDIN. And number 4, Bilat Ali, BILAT. Ali. Should not be proceeded as to why a suo motu appeal should not be registered against so and so. Make it this way. As to why suo motu appeal should not be registered against so and so, these 4 people. In view of the reasons already assigned in the order dated 15/6/2023, and moreover, why no, not that. Stop like that. We can record you as your query to the court, is that you can also have liberty to bleed. Correct. On the query made by the learned counsel for the appellants, comma, court is of the opinion that this order shall not prejudice them to file an appeal against acquittal. Next, be that as it may, both sides will address the court on the query of the court. List on when?
If possible, 12th March, 12th March, if possible.
12th March. Okay. 12th March is, no, make it 11th. We don't want to, 11th or 13th, whenever you want.
11th.
Okay, 11/3/2024. Acha. I think somewhere the top right, as per the process service report received from the Chief Judicial Magistrate Bopena, notice is already served on Ali Bhuiyan. These are the full names, huh? Full names in connection with criminal appeal number 82 of 2018. They are represented by you. Who are represented? No, then for this, who are appearing? Notice is nobody is appearing.
Learned counsel.
These 4 people are served. This is Ali Bhuiya, Sahajan Bhuiya, Nurul Bhuiya, and Anisul Rahman. Okay, A Hawk. Okay. Full stop, Howard, none appears on call. Although the name of Mr. N. Hawk, A Hawk, current counsel, is reflected in the cause list. Yeah, is reflected in the cause list. This is item number 13. Okay. His name is there in the cause list. Okay, that's all.
Highly obliged, highly obliged.
Mr. Datta was here.
Look at that code of the item.
Okay.
Single bench, item 1 for hearing, RSA 11/11.
Lord, on the last day, I had advanced the first part of my argument. That being.
Pardon me?
Most probably he concluded his argument on last day.
He was on substantial question of law number 1. He had ended while he was replying in substantial question of law. Number 1. Yes.
No, Lord, first argument that I had advanced was that the question of adoption being a factual issue, it is not open to the appellant to urge that there is insufficient evidence. Had it been a case of perversity, the question would have been otherwise. But since on the record, there are some evidence to indicate that Haro was an adopted son, that finding of fact should not be reversed on the ground that there could have been better evidence. For that, I had placed the judgment. Now, second ground regarding the adoption was perhaps that there was no proof of that ceremony, the adoption ceremony. Now, so therefore, the question would arise as to whether proof of ceremony is mandatory or whether in view of attending circumstances, the court can presume an adoption. My lord, for that, I'll just place two judgments of the Supreme Court. First is the judgment of Devi Prasad, L. Devi Prasad, which was also referred in the appellate judgment. Just two paragraphs from that.
Just give the citation to Mr.
AIR 1970, 1 SCC 670. 71 SCC 670.
Yes.
Para 9, if your lordship takes up. Amazing. There is no doubt that burden of proving satisfactorily that he was adopted by his natural father
and received by Gopal Das as his adoptive son is on Shyam Behari Lal. But as observed by the Judicial Committee of the Privy Council in Rajendra Nath Haldar versus Jogendra Nath Banerjee, that although the person who pleads that he had been adopted is bound to prove his title as adopted son, and as a fact, yet from the long period during which he had been received as an adopted son, every allowance for the absence of evidence to prove such fact was to be favorably entertained, and that the case was analogous to that in which the legitimacy of a person in possession had been acquiesced in for a considerable time, and afterwards impeached by a party who had a right to question the legitimacy, where the defendant, in order to defend his status, is allowed to invoke against the claimant every presumption which arises from long recognition of his legitimacy by members of his family. That in the case of a Hindu, long recognition as an adopted son raised even a stronger presumption in favor of the validity of his adoption, arising from the possibility of the loss of rights in his own family by being adopted in another family. In Roop Narayan versus Gopal Devi, the Judicial Committee observed that in the absence of direct evidence, much value has to be attached to the fact that the alleged adopted son had without controversy succeeded to his adoptive father's estate and enjoyed till his death, and that documents during his life and after his death were framed upon the basis of adoption. A division bench of the Orissa High Court in Balinki Padhano versus Gopal Krishna Padhano, and that in case of an ancient adoption, evidence showing that the boy was treated for a long time as the adopted son at a time when there was no controversy sufficient to prove the adoption, although evidence of actual giving and taking is not forthcoming. We are in agreement with the views expressed in the decisions referred to above. In the case of all ancient transaction, it is but natural that positive oral evidence will be lacking. Passage of time gradually wipes out such evidence. Human affairs often have to be judged on the basis of probability. Rendering of justice will become impossible if a particular mode of proof is insisted upon under all circumstances. In judging whether an adoption pleaded has been satisfactorily proved or not, we have to bear in mind the lapse of time between the date of the alleged adoption and the date on which the concerned party is required to adduce proof. In the case of an adoption said to have taken place years before the same is questioned, most important evidence is likely to be that of the alleged adoptive father held out the person claiming to have been adopted as his son. The latter treated the former as his father, and their relations and friends treated them as father and son. There is no predetermined way of proving a fact. A fact is said to have been proved whether, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. Hence, if after taking an overall view of the evidence adduced in the case, we are satisfied that the adoption pleaded is true, we must necessarily proceed on the basis, in the absence of any evidence to the contrary, that it is a valid adoption as well. Now, my lord, the next judgment of 2018 has also placed reliance on this judgment and has added a paragraph 6. It is reported in 2018 9 is 66. Kamla Rani versus Ram Lalit Rani.
Yes. Paragraph.
Paragraph 6. Just one passage from it. 6, my lord, we cannot lose sight of the principle that though the factum of adoption and its validity has to be duly proved, and formal ceremony of giving and taking is an essential ingredient for a valid adoption, long duration of time during which a person is treated as adopted cannot be ignored, and by itself may in the circumstances carry a presumption in favor of adoption. In this regard, we may refer to the observations made by this court in so LBB Prasad is thereafter quoted. So, my lord, just to recapitulate from the evidence, my lord, like I had submitted yesterday, PWs have admitted that my father was always staying with them. It is concerning my father's adoption that happened in way back in 1943, my lord. There is evidence to the effect that my father was always staying with them. There is admission to the effect that my father's marriage was also arranged by Purni and her husband. PW3 has said that I have done we had done the last rituals of Purni, and he was a Palita Putra. DW3, who was a neighbor, has also said that I was a Palita Putra. And lastly, my lord, the gift deed which was executed.
Palita Putra is PW 2 and 3.
PW3 and DW3.
PW 3 and DW 3.
And in exhibit call, that is call the gift deed, Purni, the recitals of the gift deed indicate that we were referred to as Nij Natis, grandsons. So, my lord, even though there may not be any direct evidence regarding the ceremony or giving in and taking in adoption, these attending circumstances can lead to the presumption. And since the appellate court had rendered a finding of fact on this issue, the same is not assailable under section 100. Now, my lord, moving on, if for instance, if your lordship eventually holds that the adoption is not validly proven, then we may have to make an alternate argument, my lord. And that argument is concerning the gift deed which was executed during pendency. Now, your lordship recollect that the trial court had held that the gift deed was duly executed, and it is also not hit by 52 because eventually the pendant transferee would just be bound by the decree and it will not be honest. So, but that finding was reversed by the appellate court, although no detailed discussion was made. It said that the deed having admittedly been executed during pendency is hit by section 52. Now, my lord, the second substantial question of law perhaps is a little misconceived because that gift deed was never relied upon. Now they have questioned the gift deed again by proposing that substantial question of law 2. Now, a substantial question of law number 2 was whether the gift deed was proved as required under 68 of the Evidence Act. Now, this was a finding that was in their favor in as much as the appellate court said that this is 8 by 52. And the basic thrust of the appellate judgment for deciding in my favor was adoption and not the gift deed. So this question, in my respectful understanding, was unnecessary. But having said that, my lord, since the appellate court had reversed the findings of the trial court, my lord, I crave leave to argue against that particular finding that was rendered by the first appellate court. Now, for that, perhaps I'll have to first satisfy whether I can be permitted to argue, my lord. For that, if your lordship takes up 4122 for a moment, my lord, I'll just refer to the provision and then a judgment. Order 41, Rule 20. I may read. Rule 22, upon hearing, respondent may object to decree as if he had preferred separate appeal. Any respondent, though he may not have appealed from any part of the decree, may not only support the decree, but may also state that the finding against him in the court below in respect of any issue ought to have been in his favor, and may also take any cross objection to the decree which he could have taken by way of appeal, provided he has filed such objection in the appellate court within 1 month from the date of service or on him or his pleader of the notice of the day fixed for hearing of the appeal, or within such further time as the appellate court may see fit to allow. Now, if I've understood it correctly, my lord, if the decree is in my favor, the whole of the decree is in my favor, then insofar as findings in any issue are concerned, I can challenge them as a respondent without filing a cross objection. And the option, there's merely an option to file a cross objection cross objection to the decree, and it's optional. Now, Banarsi versus Rampal's judgment had dealt with this issue, which was reported in 2003 9 SCC 606. Para 9 onwards. Paragraph 9, any respondent, though he may not have filed an appeal from any part of the decree, may still support the decree to the extent to which it is already in his favor by laying challenge to a finding recorded in the impugned judgment against him. Where a plaintiff seeks a decree against the defendant on grounds A and B, and any of the two grounds being enough to entitle the plaintiff to a decree, and the court has passed a decree on ground A, deciding it for the plaintiff, while ground B has been decided against the plaintiff in an appeal preferred by the appellant, in spite of the finding on ground A being reversed, the plaintiff as a respondent can still seek to support the decree by challenging the finding on ground B. and persuade the appellate court to form an opinion that in spite of finding on ground A being reversed to the benefit of the defendant appellant, the decree could still be sustained by reversing the findings on ground B, though the plaintiff respondent neither preferred an appeal of his own nor taken any objection. A right to file an appeal or objection is the exercise of right to appeal in a different form. It was observed in Sahadu Gangaram Bhagade versus Special Deputy Collector Ahmednagar that the right given to a respondent in an appeal to file cross-objection is a right given to the same extent as is a right of appeal to lay challenge to the impugned decree if he can be said to be aggrieved thereby. Taking any cross-objection is the exercise of right of appeal and takes the place of cross-appeal, though the form differs. Thus, it is clear that just as an appeal is preferred by a person aggrieved by the decree, so also a cross-objection is preferred by one who is said to be aggrieved by the decree. A party who has fully succeeded in the suit can and needs to neither prefer an appeal nor take any cross-objection, though certain finding may be against it. Appeal and cross-objection both are filed against decree and not against judgment, and certainly not against any finding recorded in a judgment. This was the well-settled position of law under the unamended CPC. The CPC amendment of 1976 has not materially or substantially altered the law except for a marginal difference. Even under the amended 4122 sub-rule 1, a party in whose favor the decree stands in its entirety is neither entitled nor obliged to prefer any cross-objection. However, the insertion made in the text of sub-rule 1 makes it permissible to file a cross-objection against the finding. The difference which has resulted we will shortly state. A respondent may defend himself without filing any cross-objection to the extent to which the decree is in his favor. However, if he proposes to attack any part of the decree, he must take cross-objection. The amendment inserted by 1976 amendment is clarificatory and also enabling, and this may be made precise by analyzing the provision. There may be three situations. Number one, the impugned decree is partly in favor of the appellant and partly in favor of the respondent. Two, the decree is entirely in favor of the respondent, though an issue has been decided against the respondent. Three, the decree is entirely in favor of the respondent and all the issues have also been answered in favor of the respondent, but there is a finding in the judgment which goes against the respondent. In the type of case 1, it was necessary for the respondent to file an appeal or take cross-objection against the part of the decree which is against him if he seeks to get rid of the same. So that part of the decree which is in his favor is entitled to support without it taking any cross-objection. The law remains so post-amendment 2. In the type of cases 2 and 3, pre-amendment CPC did not entitle nor permit the respondent to take any cross-objection as he was not the person aggrieved by the decree. Under the amended CPC read in the light of the explanation, though it is still not necessary for the respondent to take any cross-objection laying challenge to the finding adverse to him as the decree is entirely in his favor and he may support the decree without cross-objection, the amendment made in the text of sub-rule 1, read with the explanation newly inserted, gives him a right to take cross-objection to a finding recorded against him, either while answering an issue or while dealing with an issue. The advantage of preferring such cross-objection is spelled out by sub-rule 4. In spite of the original appeal having been withdrawn or dismissed for default, the cross-objection taken to any finding by the respondent shall still be available to be adjudicated upon on merits, which remedy was not available to the respondent under the unamended CPC. In the pre-amendment era, the withdrawal or dismissal of default of the original appeal disabled the respondent to question the correctness or otherwise of any finding recorded against the respondent.
Just a moment. Mr. Chaudhary, please come forward. Mr. Nath, there's a, yes, it's fixed on 13th. 13th, this bench may not be available. So ask them not to come. Mr. Sharma is coming in the matter.
I was informed by that.
Okay. So we'll fix a date and we'll inform. So your officers are also coming, so please ask them not to come. 13 because this bench may not be there. We'll fix it because it is for the registry to do it. But on that day, I just called you to just say that since the bench will not be there, we don't want people to come and then go home. Unproductive, unproductive. Unproductive, they may not come. So we, because not informing, we will now inform the registry also that you have been communicated of this. Okay. You will leave. It's only for that. We are not here.
So my lord, since it's a mere finding and the decree is wholly in my favor, filing of a cross objection is not necessary. In fact, under the new amended CPC, I may file a cross objection, but only benefit that may follow is that even if the appeal is dismissed for non-prosecution or is withdrawn, the cross objection would nonetheless continue, like in the case of a counterclaim, perhaps, if I've understood it correctly. So far as this issue is concerned, regarding.
No,
these-
but you see this this judgment you are saying there should be some word there must be some word, some meaning for the word. You see, the right to appeal to lay challenge to the impugned decree. Correct. To lay challenge to the impugned decree. That is what the words are at paragraph 9.
Yes.
To lay a challenge. Now, how can you lay a challenge? You see, although we don't doubt the ability of Mr. Bhatti to respond to you, but the fact is that he must have notice to respond to it. Because otherwise, Order 41 Rule 2, it says that it should be heard on the ground set forth in appeal. Therefore, parties are required to have notice of this plea being taken. That is why the words used are lay. It just can't be out of the cuff argument.
41 2, my lord, will apply insofar as the appellant is.
That's okay, but this also shows that we have limitations. We can't go astray in second appeal. So that is one part. So, because if Mr. Bhatti is ready in that, then we can take it up. Otherwise, he'll have to have notice to respond to it. You get the point?
I understand.
One can't be taken up by surprise. Mr. Bhatti?
Yes.
Although we are not doubting our ability, but the question is that when a ground is being urged.
New ground has been taken accordingly, I have to answer it.
Yes.
So therefore, that what you will require the time.
Okay. Yes. When?
Why not let it be on Monday?
No, because this bench will not be available for a week. So, we'll just say when the bench is next available.
And give it to Rajasthan on 11th.
On 11th. Oh, then this bench is not there.
And I will make there.
Okay, then we'll have to raise it because I can't keep it. But this bench is not available next week. I have a duty assigned. That's why we have called them and adjourning.
Anyhow, let it be managed in next week, madam, by sure.
No, I'll not be here. This bench is not there. That's why I've called Mr. Nath and then telling them not to bring their lawyers and their officers would have come. So we're giving them advance information.
And that is my duty. That is it, I don't know. And
You'll be back by when?
on 11th, I will go. And I will remain for 20 days in Rajasthan.
So first week of April.
Let it be kept as a part.
No, I would forget by then.
Again, only it requires only half an hour to make the motion.
No, I'm not that smart.
We try.
You have a wrong notion of, you have an incorrect notion of me. Because I can't withhold for a long time. It would be against the High Court rules.
And it is hardly the matter of 1 minute. Let it be on court appeal.
Perhaps, yes, I think it says
Or-
1 month. It says 1 month.
Yes.
Pardon me?
I think it says 1 month or a month, that's the period within which it can be kept apart.
Let's say, uh, both sides are represented.
And
your Mr.
lordship may do one thing. Your lordship may fix the date in middle of it. And on that particular date, my junior will take a one.
Yes.
So that the case can be kept as part of the first before public.
That would be better.
Should fix a second or fourth, probably that difficulty will not arise.
What the would be this scheme. Let it be a date in the middle of it, my lord. On that particular day, my junior would mention it on my ground and let it be fixed in the first before public.
No, the better we'll fix it on your arrival. In course of his submissions, Mr. B.D. Dekar and counsel for the respondent has assailed the finding of the learned trial court.
Appellate, appellate,
Issue no trouble.
appellate court. Trial court was in my favor.
No, by the appellate court, or first appellate court. To hold the what is the deed?
15 to give deed number.
Give deed, to ascend the, holding the give deed executed in favor of the respondent to be hit by, operation of section 52 of the Transfer of Property Act. First of, in order to buttress the point that a respondent can assail a finding against him without filing a cross objection, the decision of the Supreme Court of India in the case of Banarasi, BANARSI and others versus Ram RAF PHAL, Hull, within bracket 2003, bracket was 9 SCC 606. Was cited. Next paragraph. In view of the new plea being taken by the learned counsel for the respondent, Mr. O.P. Bhatti, counsel for the appellant, this was some time to address the court on the said point. First of, he has further submitted that he is likely to be out of station from 11/3/2023 till the end of March 2024, and therefore he prays that the matter be fixed on 4/4/2023. First one, the prayer is considered in law based on 4/4/2023 as part of 4/24. They will correct it. That's why I told I'm not that smart. There is one more matter that
Doctor. Sir, actually, I'm কৈছো যে চেম্বাৰতো কথা পাতিব পাৰিব
okay,
যদি দে তাৰ মানে মেটাৰ চলি আছে 2 নম্বৰ।
okay. Okay, send it to the chamber if he comes. I-
Confused হয়ে গেলেন ওর পরিস্থিতি বইতে গেলে না লাগে
Yes. Yes, sir, I agree. Because wherever those outstation council or parties are there, I'm just informing them in advance because of my certain program. Well, just since you are here, any development in that matter? And inspections are also going on? Okay. Okay, because we also have the own committee meeting. In these few days to take stock of the district-wise reports which are coming in. And have you inquired what is the conditions of the children's home and those? It's not come, okay. Just monitor in advance so that it's easier on the day.